We'd like to welcome everybody back to the Mental Health and Vulnerable Adult Task Force for day one of this meeting. And we left off with the initial conversation on vulnerable adult, number 3 on our item agenda. We went a little long and came back from lunch early and we'll continue on with that and turn the time back over to you, Speaker Summers.
Mr. Chairman, thank you. And so as we came out of this set of recommendations, I had a bill drafted on that, and that bill should all be in your packet. It is LS 24 LSO 0145 version 0.6. And so I'm going to turn this over to Anna to go through the bill. Just before I do that, we had debated whether bill, no bill. And I think the subcommittee came to the conclusion and agreed that we believe that if we bring a bill, even if it's just to create a very short-term council, that it shows the gravitas of the issue to the public and to the legislature, and then hopefully will be picked up as a committee bill and gain more momentum. We've been here before with vulnerable adults in 2017. We want to try to continue this forward to do some good things. So Anna, if you could present the bill.
Anna, before you start, for the public that might be looking, you'll see the sponsored legislation. You'll see Representative Summers here, and later on you'll see my name repeatedly. That was for drafting purposes. As these draft, if they're approved by the task force, gets forwarded on to a standing committee, it would be in their name. So go ahead, Anna.
Chairman, members of the committee, this is LSO 24 LSO 0145 entitled Vulnerable Adult Council. This bill draft would create the Vulnerable Adult Council to consist of 1 member of the Department of Health, 1 member of DFS, 1 member of the Guardian Ad Litem, 1 judicial branch member, and the chairman of Joint Labor. The council's purpose is to make legislative recommendations on whether to consolidate all state resources for vulnerable adults under 1 state agency.
A little closer to the mic. You're a little hard to hear.
The council's purpose is to make legislative recommendations on whether to consolidate all state resources for vulnerable adults under 1 state agency, namely DFS, or more than 1 state agency. If consolidation is recommended, the council shall also make recommendations on how to consolidate employees and resources under 1 agency, whether to conduct periodic adult protective services caseload studies, whether alternative additional funding streams are available and should be implemented, how to strengthen adult protective teams, whether to use a multidisciplinary team system to review complex vulnerable adult cases, how to increase awareness of services and supports for vulnerable adults, how to increase access to guardianship services, whether to expand the authority of the Guardian Ad Litem program to include vulnerable adults, how to implement cross-agency training regarding vulnerable adult abuse, neglect, and exploitation, and whether to include vulnerable adults as a priority population in the behavioral health redesign. And just for the task force information, another bill will be drafted for the next meeting, inserting vulnerable adults as a priority population. If instead coordination is recommended, the council shall also consider how to determine which agencies shall respond to reports of abuse, neglect, and exploitation of vulnerable adults, and how to leverage existing and alternative resources across state agencies. The council shall report its determinations and recommendations to Joint Labor and Joint Appropriations not later than September 1st, 2024. And then the council shall also seek public comment during the process of making legislative recommendations. In subsection G, that allows for salary per diem and travel expenses for members of the council. And then the council shall terminate June 30th, 2026. Section 2 is an appropriation section, and then section 3 provides for an immediate effective date. And with that, I'd stand for any questions.
Are any questions of Anna? You know, one thing, we've kind of changed that date to speed it up to get that recommendation in next year. So we'd be going into the following year into a general session. We felt like we had money for a while to run, and I'm going to ask Director Schmidt a little more about that. The one thing we didn't do, and I just as a note, we didn't change the end date of the council, really, and this is a question I'll throw back at Director Schmidt as well. We end the council, June 30th, 2026, and I wonder if we couldn't end that June 30th, 2025, since we're getting the recommendations out in 2024. So Director Schmidt, do you have any comments on this? And what I'll do is I'll get just some general comments from the committee, and then we'll take public comment on the entire topic of vulnerable adults, and then we'll come back to the bill.
Mr. Chairman, Speaker Summers, the ARPA money that we have that came to us directly from the feds does expire. We cannot provide services beyond September 30th, 2024. So the money that we have will basically expire by beforehand. So it does put us into the situation with those 20 slots that we've purchased through guardianship services will no longer be available. At that point, we will reconsider and look at our budget and then make some determinations about how much of the $80,000 that we receive could be allocated toward that, or if there's additional funds elsewhere until a legislative decision is made about what to do with guardianship as a whole.
Thank you. And just a general comment. I mean, also the executive branch, once you come out with recommendations, even if it's late, the governor ultimately has the ability to get it in the budget or get it in a letter. If he wants to make a recommendation, for example, if he feels it's worthy of that. So I think we have lots of options there to get it in front of some appropriations if we need it. Are there any questions of Anna? Anybody? Let's see anybody, don't see anybody online. So I think we're good. So I think we'll just go with public comment. I'll do those folks in the room first. Anybody public comment in the room on any vulnerable adult topic around policy? Obviously, this bill, you can be specific to this bill or not. Mr. Laycock, please join us.
Good morning, Chairman and Committee. I'm Tom Laycock, Associate State Director at AERP Wyoming. Thank the committee today for devoting some time to protecting vulnerable adults. It's appreciated. During the committee's last meeting in Cheyenne on May 12th, the committee explored the concept of a change to the state's statutory definition of vulnerable adult. As I'm not an attorney or direct care worker or anyone, I'd spent considerable amount of time speaking to those who actually work in those professions over the last month to find out if a definition change is needed. While no one came out and offered specific language changes for the definition, there was 100% agreement that if we can give our prosecutors a better tool for protecting our most vulnerable adults, continuing the conversation around a definition change is a worthy endeavor. Yesterday on the way here, I actually spoke with two people from a county attorney's office in Wyoming, and they had took the time to look over the proposed new definition and compare it to the old. They felt the draft legislation offered some very positive changes. We also had our national office analyze the proposed definition. The response was once again strong changes, two very small suggestions to the new draft, which I'm happy to talk to you about later. But in short, we don't believe that a change to the statutory definition using the proposed language in this bill would be anything but positive. Over the last month, I've spent a lot of time with those in law enforcement, adult protective services, county and federal prosecutors, and at least one former governor who was also a prosecutor. I want to offer thanks to Ms. Elisa Butler for helping me discuss these issues with our district court judges and dig a little deeper into the issue. One thing that was impressed upon me is how difficult it is to actually prosecute a vulnerable adult case. One current prosecutor told me a DA's office short on attorneys needs to determine how to prosecute what cases it has the resource to chase in an environment where we're seeing more violent crime than ever before. Another former prosecutor tells me VA cases can be difficult to prosecute without local detectives or investigators who are specifically trained in how to work these cases and then hand them over to the district or county attorney. He wondered if having specially trained DCI investigators available to work with, take over, or even just consult local law enforcement investigators might make a positive impact. I'll tell you, I also ran that by the county attorneys I talked to yesterday, and they seemed very, very much on board with that idea too. Just as important, I want to understand prosecuting these cases can mean spending time working a case where you have to prove intent to scam with a vulnerable adult as well as prove the adult is vulnerable. And that also has difficulties along with it. One prosecutor told me it's difficult to get a healthcare provider to want to make a determination on a vulnerable adult's mental capacity, as it can be difficult to hear from a trusted doctor you're now vulnerable. That has a bearing on the provider-patient relationship going forward. So I want to say, I believe the committee's goal of removing any ambiguity from the vulnerable adult statute is a worthwhile endeavor. We're here to fully support that. Hopefully, offering the new definition can give investigators some incentive to increase their rates of attempts to prosecute what sounds like a very difficult case to prove. I also want to let you know that those that I spoke to regarding the other bill drafts you're considering were very supportive of the civil cause of action requirements for APS and law enforcement to share information, as well as changing the timeline for DFS to make a comprehensive assessment from 72 hours to 14 days. Finally, I want to applaud LSO's work in examining vulnerable adult language and offering the meeting materials they did today. Thank you very much to Katie, Donna, and Anna. You guys did a great job. Thank you. With that, I'd stand for any questions.
Mr. Laycock, you know, I was really, and you'd mentioned this language last night. I was really interested in the DCI. Do you know what the statutes say in DCI for what they can and can't investigate? Is that's, you know, and we can have, I'm making a note to staff here to check whether we need to expand the language for DCI in order for them to do this, or is it just a policy decision of the governor?
Chairman Larson, Speaker Summers, I don't specifically know what that is. Now, that said, the prosecutor I talked to said that the locals can call in DCI, but they don't automatically take sort of jurisdiction in those investigations unless they're asked. If that helps.
Any questions of Mr. Laycock? Representative Larson.
Mr. Laycock, as we had what I think has been pretty extensive conversation on guardianships for this population. Is your association seeing any, as we contemplate how that guardianship picture plays out, are you guys seeing any types of services provided by guardians that should cause us concern and in ones that we ought to shy away from?
Chairman Larson, Speaker Summers, the world of guardianship is a little bit new to me. And so admittedly, I've got those questions into our national office right now to sort of get myself trained up in what that looks like. And I'm happy to get back to you with a better answer, either via email or next month when you're in Cheyenne.
If you would, if on that response, if you had just submitted into staff and then they can provide it to everyone.
Happy to.
Thank you.
Laycock, any other questions of Mr. Laycock? All right, thank you, sir. Would anybody else in the room like to testify? Nope. All right, is there anybody online that would like to testify? Nope. Okay, with that, I'll close public comment and we'll proceed to the bill. How I'm going to handle this would be like if I was handling it in any other committee. I will go page by page and ask if anybody has any suggested changes. If they do, we'll stop. We'll craft an amendment and then we'll vote on whether we want to put that in or not in, put it in. So Representative Larson.
Will you entertain just questions on content of the bill?
Sure. Okay. So I guess before I go through the bill, are there any other, general comments, questions on this bill of those here?
Mr. Chairman.
Representative Larson.
So if on page 5 of the bill, I kind of have some question on Romanet 6 on whether to include vulnerable adults as a priority population in the behavioral health redesign. And I'll probably, if you don't mind, ask for Director Johansson and Director Schmidt what their thoughts.
Representative Larson, you got, which page are you on?
I'm on page 5.
And you got a Romanet 6?
0.6. I got Romanet 10. I'm sorry.
Okay, Romanet 10. We got that. All right. Thank you.
Yeah. I should have just said X. That's shows my thank you. So whether to include a vulnerable adult. And so when we done the behavioral health redesign back in 2021 in House Bill 38, we defined those populations that we felt the state should have a responsibility for paying for mental health services. And we talk about them as, and we provide those definitions in 35-1-6-13. And it's the state level justice and non-state level justice involved. So that's those coming out of the correction system. That would be, so they're coming out, they've got mental health, substance abuse history. They'd be coming out and being released. We're saying that's a priority population to prevent recidivism. Families at high risk was put in. So trying to address families or issues, and these could be referred to by DFS, a school, or a variety of things, so that they could get counseling before the court had to intervene and disrupt the structure of the family. Then we get into adults with acute mental illness. And we get into adults with severe mental illness, both of those that could be living in your communities currently. They could be this adult population that we're talking about, easy enough. And then we have indigent clients with high needs. Again, as we talk about older adults, that they could be indigent with high needs. Indigent general access clients as well. And so I've been trying to figure out, when we consider putting the vulnerable adult, as you had, means any person 18 years of age or older who is unable to manage, take care of himself or his money, assets, or property without assistance as a result of advanced age, physical or mental disability. And so I think our current definitions of priority population talk about physical and mental disability, probably don't cover age specifically. But so as you contemplated that, I'm trying to understand why. What is it we're missing? What is it we're missing with the definition of mental illness that isn't, or excuse me, what is missing in the definition of a vulnerable adult that then we don't have taken care of in the priority population?
So, Mr. Chairman, I'm not sure I'm going to be able to answer that, other than I'm going to say whether to include. So it was the look at. This is my personal opinion. I think by naming vulnerable adult, you raise the awareness of that, and it's easier to plug maybe into a spot. I don't know. Director Schmid, you got any thoughts?
Mr. Chairman, Speaker Summers, I think the one thought that I would have around naming this population specifically would come around competency. And, the conversations we've had is that at some point, adding a number of priority populations means that everybody's a priority at some point. So how much do you indicate or send a nod to all the systems that this is what we think the state should be involved in, and to what extent? Because that's what this is. This is state purchase services with general funds primarily. And the vulnerable adult, when the conversation first came around the behavioral health redesign, honestly, personally, I didn't think about this population. And I think that is part of the problem. That as the director, it didn't even occur to me that this population would maybe need some level of service and expectation of some level of service be available to them at the local community level. But talking out of both sides of my mouth, I do recognize that dollars are limited, and especially people are limited to provide the services that we need to have provided. And so who is it that we think should be first in line, second in line, third in line? On the other side, though, that this is a population that if they can stay home, if with additional services they are successful at home, then that is going to save that same system a lot of money on the back end, because that means that they're looking at probably waiver services or skilled nursing facility. So I think the whether it should be included is a big topic that honestly, Director Johansson and I haven't really even discussed. But from where I sit, I do think it's worthy of a discussion, and I do see where competency could play into an important part of the mental health services that would be provided.
Bill Hanson.
Mr. Chairman, Speaker Summers, I agree 100% with Director Schmidt. I have no issue if this bill were to be recommended by this task force, go to a standing committee, be passed on there and get introduced. I have no issue with this being, a task for the council to make that recommendation. Getting into the content, to Chairman Larson's point, I struggle to find a scenario where this population, if it's a vulnerable adult as defined now or as defined in what's been drafted for this task force, I struggle to think of a scenario where that individual would not be considered a priority population under behavioral health redesign, either in the indigent high needs group or adults with serious mental illness, if they meet those thresholds. But to Director Schmidt's point, I don't know. And I think that's we will have, by the time we need to make recommendations here, about 2 months of eligibility and claims data in the behavioral health redesign after we implement. And I think we'll have a better idea, not only of age distribution, but need distribution. It won't be perfect. It'll be early. But we're working to implement those systems and those contracts now in advance of July 1st, when the behavioral health redesign goes live. So I don't have an issue with it being included here. I think it's an important, maybe the recommendation is, hey, we think this population is prioritized, or maybe it isn't. And do we need a statute tweak in the subsequent session for the behavioral health redesign? So no issues on my end, but it's a really good question. I hope I'm not naive. I might be, but I struggle to think of a scenario where the kind of cases that we're talking about, if there's a mental illness present and vulnerable adult adjudication, for lack of a better term, how that wouldn't be prioritized under the new scheme. But it's certainly possible, and we could take a look at it.
And Chairman Larson, I think Director Schmidt said it as well, is, one of the goals, obviously, and it's stated elsewhere in here, is to try to find community supports, right? And not outside of the community. And so if we can provide some early community supports, maybe it's better, but go ahead.
Mr. Chairman, Speaker Summers, if I may, just want to remind the group, because we focus a lot on the state dollars, because that is the majority of the community mental health system that the state's involved in. There's some federal grant dollars that are in there. But just to be clear for the group, the behavioral health redesign doesn't govern the entirety of the community mental health center practice. So, and I know this population might not always fall in this category, but if you have a primary insurance, and I know Medicare's coverage of certain behavioral health services isn't great, which I assume a large portion of this population would be on Medicare. My point being, the behavioral health redesign priority populations certainly do not preclude a mental health center from serving a population. It's just, how do you serve them with the state dollars? What's the priority scheme there? So just wanted to make that clear. Again, there's no issue in my mind of including it as a task for the council. And I think ultimately, if I were to guess, a good percentage of this vulnerable adult population would likely, with mental health needs, would likely fit into the priority scheme anyways.
Chairman Larson.
Thank you, Representative Summers. And that was just kind of the conversation I want to have. I recognize the language of there said to consider. I was just curious on some of the conversation, and to Director Schmidt's point, when she talks about competency, I think that's what we talk about in those priority populations, is mental illness, which is going to contribute to the competency. And so it'll be an interesting discussion. I was just curious on how that went. So thank you.
And Mr. Chairman, one more thing,
Please.
if I may, Speaker Summers, just reading, I know Chairman Larson touched on it, where I think, and staff have sent me this, so I have the language in front of me. In the priority population definitions for behavioral health redesign, adults with severe mental illness means persons who, based on diagnosis and history, have a substantial probability of being unable to meet their needs for food, shelter, and medical care if they do not receive regular, so on and so forth. So again, I think the general language is there. It comes down to what Director Schmidt mentioned. What's the awareness and the referral patterns of how folks get into the system.
Good. All right. Are there any other just general comments, questions on the bill? Director Schmidt?
Mr. Chairman, Mr. Speaker, I do have a question though, and I think this is a reminder for myself as well as for others, is that when we think about vulnerable adults, we think about elderly, but the definition in our state is bigger than that. And so this speaks to the high needs children that become young adults, and where do they fit into this population? And I do see potentially a conversation there, because we do have potentially adults, young adults, ages 18 up through 25 or so, that aren't going to qualify as under an SPMI diagnosis or a DD diagnosis, but come to us with severe behaviors and living in the community with a lot of severe behaviors with underlying mental health issues. May not be the primary diagnosis of SPMI, but certainly there's mental health indicators in there. What do we do about them? And I think that part of the discussion around this particular clause in the legislation would think about that as well.
Good to know. Yeah. No, I think that I mean, we've talked from the beginning, we always think of the elderly people, but it's really much, much more. And Title 25 folks all the way down. So. All right, if there's no other comments or questions, what I'll do is I'll walk through this page by page and ask for any changes. Are there any changes on page 1? Page 2? Page 3? Page 4? Sure. Page 5. Page 6. Page 5. Please.
Going back to page 5 at the top under Romanet IX, which I think some places means 9, is how to implement cross-agency training regarding vulnerable adults. Was there conversation on how that would impact municipal and county jurisdictions? Agency, I think implies to state agencies, but we're going to have the local governments involved there. Is there?
Chairman Larson, when we did this, it was everything. That was my would you rather it say cross-agency and local government? You want to add a little something like that?
I would propose adding language as such to cross-agency and local government training.
Is there a second to that amendment? It's been moved and seconded. Is there any discussion? Okay, so what the amendment is how to implement cross-country and local government training regarding vulnerable adult abuse, neglect, and exploitation. Staff got that? All right. All those in favor say aye.
Aye.
Opposed? Motion carries. So we've adopted that amendment. Anything else on page 5? Page 6. And as we go to page 7, did you have something on 6?
So, Mr. Chairman, I guess my question then would
Chairman.
be at the top of page 6 under Romanet 3, would similar language there be applicable, or? I don't think so. Let's leave that alone. I'm sorry.
Yeah, Chair, you see, that's kind of under a different section, which is coordination between agencies. So I think that's good the way it is. You know, on page 7, and so Corin and Stefan, so the council shall terminate June 30th, 2026. Can we do that a year earlier? So June 30th, 2025. I don't see a hesitation there, so I would entertain a motion to change 26 to 25. It's been moved and seconded, moved by Baldwin, seconded by Larson. Any discussion? All those in favor say aye. Opposed? Motion carries. And then Obviously, you'll do conforming language down through the rest of the bill, right? Because you'll see you have that through the appropriation section as well. Yep. Okay, so we'd be doing conforming language really through the whole appropriation section. And that would be on both 7 and 8. Are there any other changes on 7? Any changes on 8 besides conforming changes, which would also occur on 9 as well? This is just funding legislators mostly. And then finally, we would have another conforming change on that date as well on 10. And we decided to do this act immediate. So because we're asking for a pretty quick turnaround on the report. So if we get that enacted immediately, then we can get the agencies working. So any other comments on this bill? Representative Swaniter, Chairman Swaniter.
Thank you, Mr. Chairman. Just semantical question, I guess, for LSO, why we're calling it a council instead of a task force? We have nothing else called a council, I think, in our, that's time limited with a assortment of legislators and state agencies.
I think I can answer that.
Sure.
There was a council that was recommended, if my memory serves me, in the previous task force to create a council to look at this stuff. Isn't that Director Schmidt? I think the 2017 thing has the creation of a council in it, but I might be wrong. Either of my directors remember? I don't have that. That was my recollection. But we certainly can take a look at that, right? And find out if that language was back in those 2017 recommendations.
Right, I can look at that. I can actually pull it up in a minute, I think, if you'd like me to.
We can, or we can just change it if you would rather, but that was my recollection. You want to change it? Take just a motion in a second. You can have at it if you want. All right, we're going to leave it alone. I don't think it really matters. All right, are there any other interest in any changes in the bill?
So, Mr. Chairman and Katie, what we'd like to do on this, we recognize that we can't sponsor legislation, but I still want to do a roll call vote on this.
Yes.
And then the two chairmen will get together, task force members, I think we'll visit with. I think we have a number of options of committees that this could go, excuse me, could go to. We'd like to have the opportunity to visit with some of those chairmen and see what their schedule's like, and then we'll make a decision on where we send that.
All right. I think Chairman says we're ready for a roll call.
Mr. Chairman, roll call for 24 LSO 0145. Vulnerable Adult Council for a task force recommendation. Senator Barlow.
Aye.
Senator Nethercott.
Aye.
Speaker Summers. Representative Swaniter. Co-chairman Larson. Co-chairman Baldwin. Wyoming Department of Health Director Johansson. Wyoming Department of Family Services Director Schmidt. Director Shannon from the Department of Corrections. Laurel Ballard for the Department of Education. 10 ayes.
I'll turn the gavel as it is back to Chairman Larson.
Chairman,
Yes,
sorry, over here.
yes,
Does this automatically go to joint labor health, or is
it
it
does not.
chair discretion?
It's chair's discretion that logistically, we have the potential of changing agency responsibilities that could qualify for appropriations. There's some judicial component to it. There's labor and health component to it. And so we'll visit with those, and we have representation of all of those. And so would probably like to visit with some of those chairmen.
The reason I ask is I can't remember on the schedule which committee has 2 more meetings versus 1. I know Labor Health only has one more.
Nations, they meet all year long. Mr. Chair.
Moving along, we're on to item 4 or item 5 of our agenda for today, the vulnerable adult draft legislation. I would remind this committee, and for the benefit of the public who may be watching this for the first time, in 2017, there's a task force, a vulnerable adult task force that put a lot of work in and came back with some legislative recommendations, some of which were adopted and some that were, for whatever reason, not considered. As this group met, we looked at those recommendations that had not been worked in the legislature and thought they still had merit. And so the Senator Barlow volunteered to head a group to look at these draft legislations, redraft them, and consider any changes and present them for us today. So Senator Barlow, would like to turn the time over to you, similarly to what Representative Summers done, to walk us through these, and please take any of the public comment that you'd like to. You're driving the boat until we get done.
Thank you, Mr. Chairman. So I do appreciate it. I had to step away, so first I missed some of the last proceeding, but thank you. So, ladies and gentlemen, as the good chairman laid out, these were ideas that came out of the 2017 work. Actually, the vulnerable adult definition issue came back as a piece of legislation, I think 2 years ago, did not pass. But so this has been ongoing work. First, I'd like to point out that Donna Shippen, in our materials, Donna Shippen has 2 very, I think, good fact sheets that have been done. The first one is on the civil action or civil cause of action, excuse me. And the second one is statutory view of vulnerable adults. So, Mr. Chairman, and I see the way this is kind of laid out, that we're going to take, maybe some overview from the members, and then some public comment, and then work the bills. But I think it might be, if with your permission, I might just kind of just briefly talk about what each one of the bills do and how we prioritized them, if we prioritized them. So I would say the group has met twice, both virtual meetings, an hour plus each, and based on the good work that Donna and our staff did, kind of walk through some of these issues. So the bill that we placed the highest priority in throughout this process was understanding whether we actually need to take on the vulnerable adult definition change or changes. So as I pointed out, Ms. Shippen did a nice fact sheet. As we analyzed that fact sheet and had a subsequent meeting, and got feedback from Director Schmidt and some other folks, Senator Nethercott talked to some attorneys, etc. I think our takeaway was that the definition is, well, there wasn't a lot of appetite to go after to prioritize the definition as a bill draft moving forward. And what much of the discussion was that we had was, it comes down to a resources, training, and I don't know that will is the right word, but just comfortableness, if you will, of pursuing these vulnerable adult allegations and subsequent legal actions. So within the law enforcement and potentially within county attorney's office, prosecuting attorney's offices. So I just want to lay that out. The bills, that's the last bill on the agenda. And I don't know if that was purposeful, but actually that was our highest priority to try to understand if we want to take it on. And now I think our recommendation out of our working group would be, it's probably not, we don't know that it's necessary to change it now. Maybe there's some other things we can take take on that it might actually get assist with the challenges that we may be having. The other three bills are, very, one is a new concept in our statutes. That's a civil cause of action. And that was, I guess, fairly straightforward as far as a bill draft. Certainly has some context that certainly our attorney, Ms. Nethercott and Anna can speak about. And then across reporting, we've heard about that one already this morning's testimony about making sure DFS and law enforcement, actually are sharing information, and we have a completeness of the pictures that may be out there. And then the protective orders is a timeline type issue. So, Mr. Chairman, I guess if you're okay, and if this isn't working with me chairing from remotely, I'd be glad to turn it back to you, Chairman Larson. But I guess I'd invite maybe first Senator Nethercott and then Director Schmidt just to give any particular thoughts they want on the process or any of these particular bills. And then we, at your leisure, we can go to people that may be in the room or may be interested in testifying. Now, to be clear, I did not, I invite the WASCOP folks, the Post Commission. I did speak with Mr. Laycock, and I believe he's in the room for AARP, and he thought he would offer some comments. So anyway, Mr. Chairman, is that an acceptable way to start? Maybe a few comments from task force members or working group members, and then go to public?
That works great. And Senator Barlow and Chairman Nethercott, if and when you're making comments, I don't know that you can see us as a whole. And so if there's a question arise, I may just interrupt and allow that question to be asked as I find a gap in your conversation.
Thank you very much.
But everything, I think it's working fine. Appreciate it.
Thank you very much. So I guess the opportunity for Senator Nethercott, if you wanted to make any comments about the process we went through or any particular takeaways that you want the group to know about on what we considered. Thank you.
Thank you, Mr. Chairman. Thank you, Senator Barlow. I really don't have anything more substantive to add. Just to circle back and prioritize our time. Broad consensus across the state and amongst the stakeholders we spoke to is not to change the definition of a vulnerable adult. I personally question whether or not that's just more out of a resistance to change and a concern over making it worse, as opposed to thinking about what a better definition may be. That said, if there's no will amongst the people who live and work in this space, then let's leave it alone. There's some excitement amongst the bar for those practitioners who practice here for the vulnerable adult civil cause of action. I think that that's very worthy cause for us to move forward. And then, of course, bridging that gap of cross-reporting between law enforcement and DFS. So pretty easy, I think, topics for us to move through. And I would suggest, Mr. Chairman, to you is to start working through those bill drafts, probably to consolidate time.
Thank you. Director Schmidt, any basic comments? You actually interacted with your colleagues in Utah and some other places regarding the definition and the changes they made some 20 years ago. So any insight that you would like to share kind of where we are? I agree. I'd like to just get to work bill drafts and go, but I also know there's other people in the room. Director Schmidt, and then I don't know if Ms. Butler is there because she also participated in both of our meetings and was provided feedback from the courts, from the district courts. And then I think Chairman Zwanitzer was in on one of the calls too. So anyway, Director Schmidt.
And Eric or Senator Barlow, Elise is not here. She had other obligations on her court responsibilities, so she's not joining us.
Thank you. I think she'll try this. Director Schmidt.
Mr. Chairman and Senator Barlow, just to kind of iterate what the Chief Justice said, that the judges really didn't have a whole lot to say about the definition before she left, that they were, I think, I don't necessarily want to say fine, but I think they were rather ambiguous or ambivalent as to the definition. But one of the missing pieces that I think I would like to hear about, if it's possible, was some of the backdrop behind the conversation with the prosecutors about their concerns with the current definition and whether any additional words to the definition would help them from a prosecutorial comfort standpoint. The comment that related to that was in a discussion with a colleague in Utah. And they had about 20 years ago expanded their definition to be a little bit more succinct and direct. And my question was, did that help? The response to that question was, in some places, yes, in some places, no. So to speak back to Senator Nethercott's comment, some of it may be just discomfort with the definition and not really wanting to make any changes and therefore not exercising the discretion that's available to be able to pursue a prosecution based on that definition. But if there's an opportunity to hear from Mr. Laycock again about his conversation with the prosecutors, I'd be interested in that.
Thank you very much.
Senator Barlow, when
Go ahead.
you get ready, just know that Alan Thompson with WASCOP's ready for public comment, and so is Chris Walsh with Post at the appropriate time.
Well, I think it's, but are they in the room or are they online? I don't have a.
They're online.
Perfect. So I guess they're already admitted as so I guess, Mr. Thompson, if you would like to open your camera up and unmute and introduce yourself and provide testimony. And I think you could talk about the entire suite of those 4 bills and certainly anything else that might be of interest to the vulnerable adult discussion as a whole. Thank you, sir. Please proceed.
Thank you, Mr. Chairman. Can you hear me all right?
I can hear. Mr. Chairman Larson, can you hear?
We can. Yeah.
Thank you. Please proceed.
Thank you. My name is Alan Thompson. I'm the newly appointed Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. I'm coming to you today from Sheridan. I do apologize for not being there in person. I had some commitments this morning I couldn't avoid. But I have been speaking with our membership across the state about the discussion that this task force had back in May. I did review that in entirety. Took a look at the agenda today and the draft bills, and sought some input from our members across the state. I would like to mention before we get into the bills that CIT was a discussion in May, and I wanted to report to you that since our last information we shared with this committee or with this task force, that we've got an additional 20 law enforcement members trained in CIT, and we're continuing on that goal of offering that training across the state. As we get into this draft legislation, I guess I'll start with the definition because from the law enforcement standpoint, that was the one thing that it seemed like our members were supportive of that definition change. Now, obviously, there's more to a law enforcement investigation to get successful prosecution, and I think we would defer to the county attorneys on what they determine is, the language they need for successful prosecution. And then as we look at the reporting requirement, that 24 LSO 0023, most of our members had no issue with that change in wording in the statute. I was just wondering if that might be something that could clog up the communication system. If we see a huge number of maybe scam reports or things like that start to be reviewed by APS, is that going to cause any clogging of the communication highway? That's my only concern with that portion of the statute. And then 24 LSO 0021 emergency services, we would support that. In those cases where we would need to expanding those days, shouldn't be an issue to law enforcement at all. And then of course the civil cause of action, we don't really have any input on that, but it does appear to be a good point. And that's just kind of a quick overview. Once again, I thank you for the opportunity to be here, and I stand for any questions you may have.
Thank you very much and congratulations on your new position. I think you had to resign one to take this one. Isn't that correct?
I did. I had my last one of those meetings this morning. That's why I couldn't be there in Lander today.
Yeah, so Mr. Thompson was an elected county commissioner in Sheridan County and broke my cousin Ida Thompson's heart when you moved on, who is a county clerk. So anyway, well, thank you very much, Mr. Thompson. I don't have to call you Commissioner Thompson anymore. You're moved on. So, Mr. Chairman, is there any of the members of the task or the working group task force have any questions for? I guess he was former sheriff, former commissioner, Mr. Thompson.
Mr. Chairman.
Please, another copy.
Thank you. I just have a question about if there's any data or any way to pull data about how many reports law enforcement gets concerning this type of subject matter, particularly financial exploitation. I think it's somewhat easier for law enforcement to do a physical abuse type of a case. But I suspect that county attorneys don't actually see most of these reports or learn about most of these calls because it's determined to be a civil matter quite readily or quickly due to the facts and circumstances associated. I think we heard Ms. Smith indicate or kind of warn, and I double down on that as well, that much of this abuse is conducted by a family member. And oftentimes there are some type of legal documents like a power of attorney that facilitates the type of abuse that we're all talking about or sometimes talking about. And so, I just don't think law enforcement is equipped or trained to investigate those cases. And I was just curious if there's any data that would indicate any successful prosecutions associated with those types of crime reports, or if there's a way to find that.
Thank you, Senator Anacostia. I think there may be two questions. One is the data on successful prosecutions, but I think probably the more fundamental is there a way to actually get our hands around how many of these reports are you actually getting, or is law enforcement across the state, the multiple jurisdictions getting? So both of those, please, Mr. Thompson.
Mr. Chairman, to answer the good senator's question, I did attempt to get as much of that information in the short time frame that I've been in this position, and it's proved to be pretty difficult. The consensus that I had talking with administrators was that there appears to be a number of reports of financial the financial aspect of vulnerable adult that for whatever reason don't make it to prosecution, and that same consensus that it would appear to be easier to prosecute the kind of the physical side of this crime than the financial side of this crime. And I can't think of a way to actually gather that data short of polling every agency and getting a response from every agency. Not every agency in the state of Wyoming is a member of WASCA. So as I travel around to meet the members that I serve, I will be asking this question because it is, goes hand in hand with the mental health discussion. And this is, on the forefront of WASCOP's mission right now. So I will be attempting to gather more information on this as the days go forward. But I would agree that the financial side of it is a little bit harder to track and get actual data on, short of voluntary reporting by every agency.
Thank you. Senator Nethercott, did you have a follow-up?
No, I just would like to point out really that gap in our system that is significant. And that's kind of triggering back to the civil cause of action that may help address that at some level. But you have to recognize that requires that victim to hire counsel and move forward. And so where do those proceeds come from, right? And so when, again, we're talking about these vulnerable populations, you may not be talking about somebody who's so severely ill or incompetent that social services is involved and everyone knows this frequent flyer. But it's actually that kind of that population in Wyoming that we struggle with, that kind of working poor, right? So, they don't ever have the resources they need. And so that is who we're targeting, or that is who I think That's the population here in Wyoming that's not getting addressed.
Thank you, Senator Endicott. Yeah,
Yeah,
thank you very much. And I think
Senator
one of the,
Barlow.
go ahead, please.
Senator
Sure.
Barlow, this Representative Larson, if I could ask Mr. Thompson a question, a follow-up question.
Please proceed.
So Mr. Thompson, on that bill, on the reporting bill, and I think that the bill really does attempt to close an unintended gap. But on the second page there, we take the existing bill and we amend it a little bit, and it says if the law enforcement officer receives a report, and I don't know that I understand the process very well, but it would seem to me that the agency would receive the report and then assign an officer to investigate. And if I'm understanding that correctly, I may suggest an amendment to suggest that if a law enforcement agency receives a report, then that agency is then responsible to make the report. So that's my first question. And then I think that we probably ought to consider a reasonable time frame that report is made to DFS. And I don't, it's a swag for me on what that might be, and would look for a little direction from you. Should it be within 12 hours, 24 hours, 12 years? What should that be from the time that that report came in?
Go ahead, Mr. Thompson.
Thank you, Mr. Chair. The time frame, I guess, would be, I would suggest that would be a time frame that's manageable. Oftentimes you have an investigation that starts in, and then at what point do we have a complete enough case report that we can forward on to APS for their follow-up, and then add to that later on. I would say several days at least to get that report to APS. You have holiday weekends and so forth, like 4-day weekends, maybe sometimes that your local DFS office isn't open. So getting that to them as soon as practical in the next business week would be a suggestion. And then I'm sorry, Mr. Chairman, there was another question that I skipped on that.
The second question was the officer versus the agency doing the notification of the department. I think, is that accurate, Mr. Larson or Representative Larson?
That is.
Thank you.
Mr. Chairman, I think the question last meeting also was what constitutes a report. Generally in law enforcement, somebody will call or otherwise contact a dispatch center or a law enforcement officer that they encounter and report something to them. It's my understanding that most agencies consider that a report of something, and they take action at that point, whether it be an investigation, or just a conversation with the reporting party. And that's then documented depending on policy and the agency. So any encounter that someone has with someone on the street or a traffic stop isn't always documented in a case report. But these cases would generally require some sort of investigation to determine if a crime was committed. In almost all of these cases, a case report would be generated from that agency. And that's likely what document would be shared with APS for fulfilling this reporting requirement.
Thank you, Mr. Thompson.
Follow up, Mr. Chairman.
Please go ahead.
So, Mr. Thompson, I appreciate making a reasonable amount of time, and I would compliment you on your dancing skills. I appreciate the time that we need to allow, but we also have to take in consideration the vulnerable adult, the victim, whatever we'd want to call them. And so, I would think, I'm thinking like within 24, 48 hours. Am I just being unreasonable in that thought?
Mr. Thompson, you don't have to make a judgment on reasonableness, but your thoughts would be appreciated.
Sure. Mr. Chairman, when you get those reports on a Saturday night and there's something that you're working an investigation on right away, maybe even working on a search warrant or an arrest, it's going to be a priority. And notifying APS at that time when it's in the law enforcement's realm where they're already trying to seek services for that person, at least in the short term. I'm not sure that 24 hours is needed there. I think the goal would be for this, for all of us to come together and getting this victim the services that they need in a timely manner. And if law enforcement is providing that in the short term, notification in 72 hours or something like that to APS, I would think would be sufficient. And I would definitely defer to the professionals with DFS. And
Thank you very much, Mr. Thompson. So I think one thing we should be clear about, the way I interpret this potential change to statute is that what's being conceived in this is an allegation of abuse, neglect. These changes with an allegation that should be reported. That's the report that would be reported versus a investigation and subsequent report when there's a determination that something has occurred. So I think there's a fundamental difference there. Maybe Director Schmidt, this was something of interest to you because you're trying to close some communication gaps. So would you speak to this? I think the difference is allegation versus completed report type of thing. Would you be able to visit on that? Thank you.
Mr. Chairman, Senator Barlow, yes, I think it's important to know the context of this particular piece of legislation in relationship to the overall current statute. And this is a mandatory reporting type statute. So similar to when there's suspected abuse and neglect of a child, there's a mandatory reporting requirement that says that if someone thinks that an adult is being abused, neglected, and has reasonable cause to believe that a vulnerable adult is being or has been abused, neglected, exploited, intimidated, or abandoned, or is committing self-neglect, shall report the information immediately to a law enforcement agency or the department. And I think that's important because as the language sits right now, the department, if it gets a report for a mandatory reporter that there's suspicion, we then turn around and call law enforcement. It's a report at this time. We've not confirmed or denied. It's a report. What the change in legislation does is make that reciprocal. If law enforcement is the first point of contact, then law enforcement would call us. And while I can understand to Mr. Thompson's comment about, will that increase the number of reports? Absolutely, it will. But it's also an important component of any type of investigation where we may know or have suspicions of a particular issue, but we need more cooperative information. And if law enforcement has some of that information, then jointly together, we can look at what is the best course of action. As it stands right now, though, law enforcement can look into it, dismiss it, and we would never know anything about it, even though it may be important information for us to have as we continue to look at a case. And I think it goes back to Senator Nethercott's point is that unfortunately, it's known people who are committing the abuse or the exploitation. It's caregivers, it's guardians. And so any type of information that helps us in those situations can be beneficial and also to rule out. I mean, there's also the opportunity for us to rule out any concerns too, if we're getting similar information from law enforcement.
Thank you very much. Any other members of the task or of the group there in the room have questions for Mr. Thompson?
Mr. Chairman, this is Representative Summers.
Mr. Speaker, please.
Mr. Chairman, thank you. So my question is back to an issue that was brought up by our AARP person, Tom. And it was about the use of DCI to investigate. I'm curious if, and maybe it'll take some research from the sheriffs and chiefs, but how much do they use DCI? Is DCI effective in this? Would they be effective in this? And I'd also be interested a bit in Senator Nethercott's opinion. She kind of brought up the issue as really, are we able to prosecute any of these? Would DCI help that ability to get prosecutions? So one to the sheriffs and chiefs on DCI and maybe Senator Nethercott as well.
Yeah,
Mr.
I'm gonna start with Senator Nethercott, just because she's brought up the issue, and then we'll go to the chief, please.
Mr. Chairman, thank you. So Representative Summers asked the question earlier about DCI's authority. They only have primary jurisdiction over drug offenses and computer crimes. Everything else, local law enforcement has primary jurisdictional authority. And so DCI can only get involved at the request of local law enforcement. That said, DCI is a limited agency. And so even though law enforcement may need the resources, DCI, is pretty tapped out as well for what their resources are. And so I think it's important to be very cautious about just utilizing a state law enforcement agency to do what is a very local crime, involving very community-oriented people. So I do think that there is wisdom in having local law enforcement. I think where the lack may be, and what I had mentioned before, is potentially creating a specialized division within the AG's office, similar to Medicaid fraud. Medicaid fraud is its own little division with a devoted AG to pursue Medicaid fraud because it's so niche. And then they have this kind of bizarre situation of a DCI agent in that office. He's not assigned to any other division within the state. And there's only one, and they work hand in hand investigating Medicaid fraud. And so that concept already exists in Wyoming's structure. And certainly there's a lot of crimes that would warrant this type of specialized expertise, but there does seem to be a disconnect in the ability of local law enforcement. They're getting all kinds of calls for serious violent crimes and other issues in the community. And so when they get this report that they're concerned that a daughter is exploiting her mother through a power of attorney, that's a civil matter. And they kind of step away pretty quickly because somebody's getting beaten up down the street, right? And so it's a matter of those types of resources. And so there's this whole segment out there that I don't think local law enforcement is able to prioritize or clue into because of that civil matter deference that's given. And so those are my thoughts. And then prosecutors, when you go back and you look at the definition and even law enforcement, to kind of just circle this around, I hope I'm not talking too much on this one topic, but you have to prove that they're incompetent statutorily, right? That's an element of the crime. And so your local law enforcement guy's like, well, I don't know if they're competent or not. Isn't that a doctor's determination? And I think a prosecutor, when they look at that definition, goes, that's super ambiguous, right? And is the statute even unconstitutional for being void for vagueness, or it's unconstitutionally broad? And I think those are legitimate concerns, and both for law enforcement and prosecutors. So I do think those, that's something that deserves further consideration, but that's why law enforcement, I think, steps back. So sorry about that. Sorry for the long-winded answer. Mr. Thompson on DCI.
Thank you. So I think and thank you, Senator Nethercott. So Mr. Thompson, I think the fundamental question of Speaker Summers was, is there a role for DCI, or could there be a role for some specialized type of state resource, investigatory resource? And Senator Nethercott mentioned the Medicaid fraud type approach. Any thoughts on that? And I would say, I agree, there's not, every department is not, Laramie County SO or a, Casper PD. There are a lot of small municipalities and smaller law enforcement officers that could get the same complaint, but not have the resources or et cetera, and expertise maybe to pursue this. And 23 counties of attorneys who would have to determine where they go forward. So Mr. Thompson, any thoughts to that DCI or centralized approach to potentially assisting with this issue?
Mr. Chairman, and thank you to the good senator for explaining half that question more eloquently than I could. The description of the impact on DCI, I think, was perfect. I would believe incur hiring more people, because I think if you're looking at taking that on statewide as a DCI function, it could be very impactful on DCI, where you have agencies across the state that are very well equipped and prepared to do this. And then that arrangement that we already have with the DCI across Wyoming in asking for their assistance. So in some of these smaller agencies that receive a report like this, that's just something that they can't even dedicate the time to, regardless of how much training they have on the topic. They would sometimes reach out to DCI and ask for assistance in that investigation, which I think exists right now, and is a good resource for them to move forward with this type of investigation. And not only that, those smaller agencies oftentimes have relationships with the sheriff's office in the county that might have more personnel or dedicated investigators and work on this jointly, or be able to lean on those other partners around them. In fact, depending on the level of fraud, sometimes, and across the state lines, especially, some of the federal partners are able to help when that dollar amount gets really high. It's, as far as I'm not in a position to recommend whether DCI would be interested in this or not. It's not a question I've asked, and I think that most of your local agencies have the wherewithal and the ability to investigate these adequately and get successful prosecution.
Thank you. Speaker Summers, did that get to most of what your question was? Please proceed.
Yeah, follow up, Mr. Chairman. Thank you. I mean, right at the end, I think Mr. Thompson said it, that they have, the local law enforcement has the ability to do this work. So, I guess, what do the numbers show? I mean, how many, if this is a great burden on DCI, are we talking 10 cases a year in the state? Are we talking 100 cases, 1,000 cases? How many of them are actually prosecuted? They actually started a serious investigation. I wonder if we are actually getting much done in this front on the investigation and prosecution of elder abuse. So I know it's a very tricky issue. So I guess to the sheriffs and chiefs, to Mr. Thompson, is, perhaps you can get us a little more information going along. But if we got a hole here and we're just go, okay, yeah, we're fine. That's great. If we're fine, if we're not fine, we need to know it.
Thank you. Mr. Thompson, if you'd like to respond in any way.
Mr. Chairman, thank you. Good question. I will continue to work on gathering this data and bring it back to answer this. The other thing that data I don't think is going to show is the amount of these reports or these incidents that are unreported. I hear, it's a small community in Sheridan County, and oftentimes we'll hear about these types of cases third party, and you attempt to investigate it, and you're not getting the information that you need, because the people are aware that they've been taken advantage of or scammed or whatever it may be, don't appear on face value to be vulnerable or meet the definition to move forward without a willing victim. And the case kind of stalls right there, because the evidence isn't there. I would guess that not only would our data provide you just what case reports that we have, but there's another number out there that I would love to know, and that's the unreported ones.
Thank you very much. I think that goes to what Senator Nethercott was trying to get to earlier. And I think, and I don't know that we did this, Donna or Anna, if we actually pulled the court records to see if we do have successful or prosecutions and then subsequent successful, that would be the maybe a number we could get to. Getting those other numbers is far more challenging. I can see that. Anyone else have questions for Mr. Thompson from Wascott? Senator Nethercott, please.
Mr. Chairman, just for point of discussion of this committee's work, Mr. Thompson identified, I think, what we're commonly seeing that doesn't have a remedy, where you have a person who is vulnerable but may not be incompetent, who has been scammed or a victim of fraud. And we know that a significant amount of those don't report. because of shame and embarrassment. Or it's a family member who did that to them, and they, reporting your daughter or reporting your sister is a pretty significant thing to do. So there is reporting hesitancy around those types of crimes, but there's also this gap in there again of a fraud victim, right, of our scam victim. And do they have to be so incompetent that they don't know how to take care of themselves to be vulnerable? And I've kind of addressed this with all of you before, that we all would agree that in an aging population, vulnerability increases, which isn't necessarily the same as incompetency. And should there be greater protections for that? I mean, they willingly gave their credit card number, or they went and bought the gift cards, right, through this call, and there's no remedy. They chose to do that. They chose to give their money away for whatever reason, or they signed the power of attorney. And so there is dots not connecting of people who have lost and are harmed without a remedy.
Thank you, Senator Nethercutt.
So
Thank you.
I throw a question at you, Senator. If I could, Senator.
Please
Is
go
there-
ahead.
My concern then, is there a belief that they shouldn't report if I'm elderly and I've just been a victim of fraud? I don't want to become a vulnerable adult under the statute. And if I have somebody advising me, would there be a point where they say, maybe you don't want to say you've just been scammed or defrauded because you're more likely now to not be able to take care of your own affairs and have an action against you? Is that a legitimate concern why people might not come forward? And I guess while I'm asking questions, is the problem really in the investigation, or is the problem there's not a desire to prosecute? I mean, it's low level fraud. I mean, it's not a massive felony if the threshold is under a certain case. And so do we have an issue with the investigation side of it, or do we really have an issue with prosecutors saying this doesn't rise to the level of something we actually feel like we can have a successful prosecution that could take months? Two questions there.
Thank you, Chairman Zwanitzer. So to preface, you said, yeah, okay. All right. I don't know if Senator Nethercutt wanted to weigh in because she brought this, and then I'll give Mr. Thompson a call. But I don't know that, since there's multiple groups here, right? Investigators and prosecutors, they might both have different responses to that question. I don't know that prosecutors are here represented. So Senator Nethercutt, we'll just let you just rhetorically speak. We're probably getting a little far afield maybe from getting to public comment. We're getting into a lot of the details, but go ahead. Let's try to wrap this one up.
Mr. Chairman, thank you. I think to answer Representative Zwanitzer's question, the answer is yes, as the law currently exists, that if you try, that there might be hesitancy to report that they're a vulnerable and a victim and therefore subjecting themselves to a guardianship or some other type of legal action that would take away further independent decision-making that they have. So absolutely, that is a concern. And so we can craft solutions for that to encourage reporting that doesn't necessarily trigger a full loss of that vulnerable adult's rights.
Thank you. Mr. Thompson, did you want to weigh in on anything in that discussion?
Yeah, Mr. Chairman, thank you. Just real quickly, I would say that most victims of crime like this aren't aware of the vulnerable adult statute, and they're going to report the crime or they're not going to report the crime based on their feelings on it. But once it gets to the point where they're identified as a possible vulnerable adult going to prosecution, they would, if that is an issue for them, they would be less likely to cooperate with prosecution if that title mattered to them. So to report it to law enforcement, I don't think that that's a game changer.
Thank you. Anything further from task force members? Anything for Mr. Thompson? Anything further? I can't see the room, so anything further? Hearing nothing. Thank you, Mr. Thompson. We do appreciate. Was there someone there? Okay. Thank you, Mr. Thompson. We do appreciate your, and congratulations and welcome. We look forward to your contributions as we deliberate on important things that impact your members and the state of Wyoming. I guess, Mr. Walsh, are you available to provide any testimony on this issue? Please introduce yourself and provide any testimony you'd like to on any of the 4 bills that are before us, Mr. Walsh. Thank you.
Thank you, Mr. Chair and members of the committee, and I appreciate the work you're sitting down and doing on this. My name is Chris Walsh. I'm the director of the Peace Officer Standard and Training Commission. And probably, I mean, I feel like I have a lot I could weigh in on, but Mr. Thompson, I think, covered most of it. I've been a law enforcement officer for 33 years, actually retired from the Casper PD, and have been at post for the last 4. And I was invited to discuss reporting issues and then any hurdles to prosecution. And actually, I think the role of post is certification, training, insurance training for all certified personnel across the state. And then also misconduct cases for all sworn individuals in the state. So we don't, I don't have current information on reporting, and my experience in prosecuting these cases is going to be prior to my position here. But I guess I'm here if you've got any questions of how post can assist in the work you're doing.
Thank you. So, yeah, I appreciate you being here. I guess maybe do reflect on your 33 years. You said it ended with the Casper PD. So maybe reflect a little bit with your experience, if you have, kind of have, that's a long and obviously stellar career, because now you're training the new officers coming in for us. So thank you for that. But so any reflections you would have about the investigatory, the report side of it, and then subsequently reflections on the subsequent prosecutions or not. Thank you.
Thank you. And Mr. Chairman, Senator Barlow, and I may have missed it earlier in the day because I haven't been watching the whole day, but when we talk about reporting, it would make sense to me that we would mimic something along the lines of child abuse reporting, where law enforcement agencies and DFS work together, reporting those types of crimes, and that mechanism's in place. Maybe it could be bolstered up. I'm not sure, but at the local level, the local officers and investigators speak with the local DFS individuals. And it would seem like an easy path to be able to do the same thing with what we've got going on here. And probably as far as data collection, I heard how many cases are there, how many cases are civil, how many are not prosecuted. It's going to be a large number that wouldn't be prosecuted because it turns into a civil case, just like Senator Nethercott said. But if law enforcement were reporting all those to DFS, then you would have that central repository to be able to build that data to see exactly the scope of what we've got going on.
Thank you very much. That's actually helpful. And I think that's one of the points that Director Schmidt has talked about was, if we don't know, we don't know. So when they get a report, it might have been a report to the law enforcement the week before, but there's no way to connect those two dots. So thank you. But so thank you, Mr. Walsh. Any of the members have any questions for Mr. Walsh?
Chairman, this is Representative Summers.
Please proceed.
So, Mr. Chairman, this is really a question from this morning, but because we have the post commission on, it was really around the CIT training, right? The crisis intervention training. And I'm not familiar with what's required in statute of post training, what is not. Could you give us an update on what you do in the realm of crisis intervention training? If nothing, are you thinking about adding it to the curriculum at the academy? Could you talk a little bit about that issue?
Mr. Walsh, please proceed.
Thank you, Mr. Chairman. Representative Summers, yes, I can. Currently, CIT training is a broad term applied to a lot of different trainings. It all has to do with people in crisis, emotional and mental crisis. There is I believe it's the Memphis model, which is a 40-hour training. I'm very familiar with that one. And then there's other smaller aspects of CIT training. It is not mandated at basic training currently. There has been talk about adding in more portions of a CIT type training to basic. Right now, if a peace officer, in order to maintain certification, it depends on what level they're at. They have to meet a certain threshold of hours of training within that certification period and a time of service in order to advance. And then once advanced, they have to maintain ongoing training. Peace officer has to have 10 hours of what's called perishable skills training in that 40-hour required training. CIT, de-escalation, those are aspects of perishable skills, but we don't mandate the number of hours or exactly the model or method that they use. So it would be nice to say, yes, we require CIT training and we require it to look like this, but we do not. Aspects of it are required in order to maintain certification, though.
Thank you. So to be, so your experience with Casper PD, that it was an emphasis at Casper PD, if I recall correctly, under probably 15, 20 years ago. Is that accurate? I think it was, you had a city administrator named Tom Forsland at one time. And I know that was something that was a priority, and when he was there and that your chief was there. Is that accurate?
That's completely accurate. In fact, I was a captain at the time when a sergeant presented the proposal to me. And the reason was Casper PD, we were getting multiple complaints and lawsuits because of, mostly because of what the officers were saying, not necessarily the actions. I'm the one that authorized the first class at Casper PD, and it's been continuing for probably close to 13 years now. And we saw tremendous results. Now, we used that Memphis model that was 40 hours long. Pretty intensive. It requires speaking with the mental health providers. It requires going to the different facilities that offer mental health. Also, just speaking with people who are going through mental health treatment. We saw our complaints go down quite a bit, and mostly it was the rudeness. We saw use of force complaints go down, and we saw basically a pause and a bit of patience before our officers applied, a quick arrest. So I think it's a fantastic program, and I highly advocate it.
Thank you very much. Representative Summers, did you have a follow-up?
Mr. Chairman, I did. So, a question I had is, do we in statute prescribe any of the courses that are required in basic? I guess it's concerning that maybe that's not at basic, and why, is there a review process? Do we as the legislature mandate things? Should we mandate things? Everybody's gonna say, don't mandate anything, but if you don't start down through actions, then ultimately that's what happens. So what is mandated in statute? And are you guys going to take a serious look at providing CIT training in your basic?
So go ahead, Mr. Walsh, if you would. And it's probably Director Walsh or Administrator or Chief? I don't know. What is the title? Sorry.
It's thank you, Mr. Chair. Director is the official title.
Director, okay. My apologies. I didn't use that earlier. Director Walsh, go ahead and respond to that. And, the mandating, the statute layout, the requirements for the basic post, and then, what would you think about being more specific if there's a will for that? Thank you.
Thank you, Mr. Chairman. Representative Summers, the statute does not mandate what is in basic training for peace officers, detention officers, correction officers, everybody that we oversee. That is, basic trainings are approved on a yearly basis by the Post Commission. That's a 7-person commission appointed by the governor. The Attorney General also sits on that commission. So in Wyoming, the Wyoming Law Enforcement Academy is primarily responsible for basic training. We'll present a curriculum to the Post Commission, outlining different topic areas, and those topic areas will be based on national standards and areas of of improvement that the academy identifies within the state, and then the commission approves it. So basic training must be approved by the commission. So in one sense, yes, the state does mandate what's in it. State statute does not mandate what has to be in it, but the commission does. And I know that the academy is discussing revamping. They're in the process of doing their detention basic right now, and then we'll be doing that with the peace officer. And if it would, I can bring this up. I have a commission meeting on the 27th of this month with the post commissioners and let them know that there's an interest in that if you would like me to discuss it with them.
Thank you, Director. And I think, I mean, I'm just going to say, I think that there would be an interest in just at least give them a heads up that this is really on the topic and or certainly a topic of discussion. I want to be cautious here that don't make the assumption that we're not providing any CIT training. We may not be providing the Memphis model that you referred to now twice, and what Casper PD and I think what my community is actually utilizing now too. That doesn't mean there is no what you would call CIT training that happens within the basic law enforcement. Is that accurate?
Yes, Mr. Chairman, you're completely accurate. There is training on people in emotional crisis that is sometimes triggered by intoxication or impairment, and then also people with mental health issues. So it's absolutely trained. It's just not drilled down like an advanced CIT class would be, but officers that come through basic training all have a familiarization on dealing with people with mental illness or emotional crisis.
Thank you. Would it be possible to just do a comparative, since you are very familiar with the Memphis model? And do you think that it'd be very difficult to just do a comparison with the Memphis model offers to what our current, coursework through Post is, just to see, are they getting 20 hours of the 40, and what's the similarities? Do you think that's something that's doable, and we could maybe have our staff work with you to try to elucidate that?
Yes, Mr. Chairman, that's very doable.
Thank you. Any other further questions for Director Walsh?
Mr. Chairman, Mr. Chairman.
Please proceed. Yes. Director Schmidt.
Thank you. Hi, Director Walsh. My name is Corin Schmidt, and I'm the Director of the Department of Family Services. And while the CIT conversation was earlier this morning, I think I would be interested in knowing also what it is that you train around in regard to adult protective services and child protection services as well, because that's been a topic of conversation in one of our subgroups, I can't remember which, is what is the interaction of law enforcement from a training perspective when engaging in adult protective services issues, whether that's abuse, neglect, financial exploitation, what have you. So if a quick we do X would be good, or if it's more in depth than that, maybe is it possible to have that included in the information that you provide to Senator Barlow?
Go ahead, Director Walsh.
I'm sorry, spoke out of turn, Mr. Chairman. I think it would be best if I combined it all together and then provided it, and then provide a comparative sample between the CIT, the advanced level CIT versus the basic training, and then also what's being taught on adult protective services or crimes revolving around vulnerable adults.
Yeah, I think there was also a request for the children part of that too, because they are separated in statute as well. Is that accurate, Director Schmidt?
Mr. Chairman, that was just a personal request. Certainly, Mr. Director Walsh, don't feel obligated about child protective services, but it is a conversation I'm very much interested in having with you.
Yeah, actually, I do think there is a nexus to this, because one of the bills that we're taking up is trying to connect the dots for adult protective services the same way we have it maybe for child already. So I think that there is some analogous information, or some information that would be helpful in this discussion in that. So thank you very much. Anyone else have questions for Director Walsh? Anyone else have questions for Director Walsh? All right. I guess hearing none, seeing none. Thank you very much, Director Walsh. We appreciate it. We'll look forward and Katie or Don or someone will be reaching out just to assist if you need anything or try to help flesh out the information. We can get it in a usable form for everybody, and we look forward to that. So thank you very much. I think next on our agenda, Mr. Chairman, was as far as public comment on these bills and on the posted agenda. Sorry, I'm trying to get to my agenda. Was I think Mr. Laycock is in the room, Wyoming AARP. So Mr. Laycock, if you're available and like to provide any feedback. I think one question that came up was maybe some of the interactions you had, and I know you did some visiting with various stakeholders, including, I think, prosecuting attorneys. So anything that you would like to provide us with any of these bill drafts and anything else that might have come up that is of interest and relative, please proceed as you are available.
Chairman Larson and Senator Barlow, I think I did talk a little bit before you were able to rejoin us, but there was a question about what was some of the conversation with the county and district attorneys. So the folks we talked to, our state director, Sam Shumway, has a brother who's a district attorney in Natrona County. He was able to use that to talk to his brother as well as Judge Forey. And I was able to talk with Tucker Ruby yesterday, the Johnson County attorney, as well as Representative Crago, who also works in that office. And they did have an interest in being a part of this. Unfortunately, the timing didn't work out for them very well to be in this particular endeavor. What we heard from the Johnson County attorneys was as Director Schmidt had mentioned, making sure that ability to have prosecutorial discretion was big for them in these cases as well. In the case of the Casper attorneys, they said in a lot of cases they end up prosecuting maybe more the crimes, the underlying crimes, if there's a fraud, if there's an abuse, something like that, but less so a specific vulnerable adult case itself. And so the statute wasn't necessarily quite as important to them in that regard. I think those were the big ones. And once again, the things that really jumped out was having some way to offer training or resources to the law enforcement agencies so that they're able to bring a case that's ready to prosecute. I think that was one thing that really stood out in the conversations that we had. But I thought Senator Nethercott, Senator Barlow actually did a nice job of sort of prioritizing where these efforts would go in terms of the 4 bill drafts.
Mr. Laycock, if I could, you mentioned the training, and did any of them have any suggestions about where that training, where that support comes from for investigating and then hopefully as appropriate prosecuting these crimes in your discussions?
Chairman Larson, Senator Barlow, DCI did come up a time or two, but by the same token, I appreciated what Senator Nethercott had to say. And I know that Medicaid fraud group in the AG's office it's been a pretty successful model thus far, and that might not be a bad idea.
Okay, but no other suggestions came out, Mr. Laycock?
That is correct.
Okay, thank you. Does anybody have any questions for Mr. Laycock? And I do apologize, I missed some of that earlier testimony, so my apologies. Any questions for Mr. Laycock? Any questions? Hearing none, seeing none. Thank you very much. And I appreciate your work. I know you visit with a lot of folks, Mr. Laycock, so I thank you very much. So Mr. Chairman Larson, I guess I can't read the room, so I don't know if there's anyone else in the room that may want to provide public testimony, if there is, or online. So LSO, is there anybody that has indicated they want to provide testimony on any of these bills or this topic?
We're not seeing any, Senator Barlow.
And anyone else, anyone in the room, Chairman Larson, that is interested? I can't see all I can see is the front row of the room. So I have no idea who else is in the room.
No, there's no interest at this point.
Okay, well, Mr. Chairman, I guess, well, if we're just going to proceed to the bills and work the bills, is that acceptable to you?
Please do.
Okay, Mr. Chairman, I don't know that we need to have LSO walk through the bills in the order that they are. And we're going to leave the vulnerable adult definition one to the last, and then It's been our, as you heard, it's our recommendation that we do not forward it with a recommendation, but that certainly is the will of the entirety of the group. So, Mr. Chairman, if we'll just start with the gotta make sure my list is the same as I have them pulled up, the civil cause of action. And I think this one, of Senator Nethercott, if you would like to, I'll make one comment before we do this. I know there was a comment from the courts, from Elisa through Ms. Butler, from the Chief Justice. And in this bill, there's the term exploited or financially exploited. And financially exploited, I don't believe is otherwise is identified in statute. And so the Chief Justice's, I think, interest was maybe just to say exploited, and that would be broad enough. That is broad and would include financially exploited. But anyway, I think Senator Nethercott, if you don't mind, this is something that you've shown a lot of interest in. And do you want to, walk through the bill or just talk about it in broad sense and then we walk through it? Do you have a preference?
Mr. Chairman, so the bill really is, only 12 lines of text. So I think it's fairly, easy to work through, but we just have, so we're looking at the bill draft, creating a cause of action, a civil cause of action for the exploitation of a vulnerable adult. And I do think that recommendation that we heard from Ms. Butler is a good one and an amendment that we can make to this bill draft. And I think that's looking at page 1, line 13. So just for the committee's cluing in on where we're focusing here. And then looking at really page 2, line 1, that's really the meat of the bill. And it says the vulnerable adult may recover actual damages for the exploitation or financial exploitation. So again, I do think just making it exploitation is helpful. If the court finds that the person acted with malicious intent when exploiting or financially exploiting the vulnerable adult, then the vulnerable adult may be awarded punitive damages. The action may be brought by the vulnerable adult, that person's guardian or conservator, or by the personal representative of the estate of a deceased vulnerable adult. And then the jurisdiction for the court. And so that's the bill draft. So some key things there, I think, are who can bring the bill or who can bring the cause of action and who can, and the type of damages that are awarded. So in most types of civil causes of action, you only get compensation that is to make you whole. And that's called compensatory damages. And so that's what we see in that first line, in line 2. But then if there's this malicious conduct, and that word may be changed down the road here, but I think it's fine for our purposes today. But that punitive damages are also allowed to be awarded. And so I think that's very important that there's a specific statutory piece here. I do also think that we should probably add a line concerning the recovery of attorney fees is expressly and explicitly allowed. Under a successful cause of action is attorney fees are recoverable. And so I'll bring that amendment. But with that, Mr. Chairman, I'm happy to stand for questions about the bill draft.
Thank you very much, Senator Nethercott. Do any of the members have anything on this bill draft, just in general? And then we're just.
I do.
Go ahead, please. I think it was Chairman Zawana.
Yeah, thanks. On page 2, line 6 through 8, when we talk about who can bring the action, either the vulnerable adult, their guardian, or the representative of the estate if they're deceased. I guess my question is, what happens if it is that person's guardian or conservator who is exploiting the vulnerable adult? The vulnerable adult may not be cognizant of the legal processes and able to, testify on their behalf, and they're still alive and it's against their own guardian. So do we need a fourth category of somebody else who can work on behalf of that vulnerable adult if it is in fact against their guardian or conservator?
Thank you. Senator Nethercott, any thoughts on that?
Mr. Chairman, thank you. That's a good point. Representative Zwanitzer. if this type of civil action were being brought by a vulnerable adult against their guardian, that guardian likely would have already been removed, or that would be part of that process. That said, it may be prudent and a good idea to add more individuals that can act on the vulnerable adult's behalf without needing to be the personal guardian. And the Uniform Power of Attorney Act, you can do a petition for a review of a power of attorney's conduct. And it delineates in the statute who may petition the court for a review of a power of attorney's conduct if they have concern. And so it may be prudent, and I would ask LSO, and actually, Mr. Chairman, what I would do maybe procedurally is to bring this bill back to our next meeting and ask LSO to put in there a staff comment adopting or at least cluing us into maybe some additional potential individuals that can act on a vulnerable adult's behalf based on the Uniform Power of Attorney Act. So that's my thought.
Thank you very much. We also have that memo that was produced by Ms. Shippen that has other states. So we may take a look at that, and Alice, our staff might have find some options there as well, to either the Uniform Power Act and we have in statute, or maybe there's some other language. So thank you, Representative Zwanitzer, for bringing that up. Any other just general comments, and then we'll just walk through the bill. All right, I don't see any or hear anything, so let's just, the bill is not very long, so we'll start with page 1. I think I've already heard if there's no without objection, we're just going to strike on line 13, page 1, or financially exploited, and then make that conforming throughout the bill. Does anybody have any objection to that, just as a way to expedite what the proposal that I think Senator Nethercott also agreed with? Any discussion on that? Any discussion? So with that, we will strike the or financially exploited, make it conforming throughout. Is Anna, I don't know who's in the room there with you. Anna, is that who's staffing today?
It is.
Yeah, I just want to confirm that they got that, and it's understandable since I can't see. I see we're joined by another member of the task force here, the committee. Thank you, Senator Nethercott. Why don't you just introduce our intervening member?
This is Charlie. She's hungry and she wants dinner early today.
All right. Well, welcome. Welcome. We know who's the director there, Director Charlie. Very much. Anything further on page 1 of the bill draft? Page 1 of the bill draft. Okay, page 2, and I think Senator Nethercott, you had a attorney's fee language that you were interested in issuing.
Yes, Mr. Chairman, I would make an amendment to grant that the statute affords the ability to collect attorney fees for the successful prosecution of one of these cases. LSO can wordsmith that.
Okay, very good. Any discussion on that? We're a small enough group and I'm remote, so I'm not going to ask for a second. Somebody wants to weigh in on the motion. We'll do that verbally. We won't worry about seconds. So any discussion on that amendment? It's a conceptual amendment. LSO, I'm sure we'll have some suggestions, standard language that maybe is used elsewhere for similar type circumstances. Any discussion on that amendment? Any discussion on the amendment? Seeing none, I guess without objection, we'll just move that forward since I'm not in the room and we're not, we'll just without objection, we'll move that as an amendment for the next consideration of this bill. And then finally, Senator Nethercott, did you want something else looked at and the staff note for the next draft, or the put place in the next draft?
In addition to what we already discussed about who may bring the cause of action.
Thank you.
Also maybe some history around the word malicious. And maybe, is that anywhere else in statute?
Maybe does Anna want to weigh in with the malicious?
Mr. Chairman, Senator Nethercott, I'll look into that. And I'll add that to the staff comment.
Thank you
Were
very
you
much.
able to hear that, Eric?
Yes, I did. Thank you very much. It'll be added to the staff comment and evaluated. Thank you very much. Members of the committee, is there anything else in the bill draft that you would like to alter?
Eric, I thought there was some consideration of Chairman Swanitzer and Tara's conversation on other means of bringing action against the conservator or the guardian if they were at fault.
Yes, I think that was going to be part of that staff comment for consideration at our next meeting. Since we don't have actually any language being proposed, I think we were just going to allow a little bit of exploration into that. And then we'll take that up at when we consider this. We'll advance this draft with the changes we've adopted and then be able to consider those 2 additional items. If I misunderstood the room, if I misunderstood, please correct me, but I think that's how I understood it.
As did we, just
All right.
clarifying.
Thank you. Anything further? Anything further on this bill draft? All right, hearing or seeing nothing, I guess we'll advance this bill draft forward for the next meeting with the changes as agreed upon and consider those couple nuances as we get more information. Mr. Chairman, without objection, I'll proceed to the next bill draft, which is the cross reporting. It's 0023 DFS law enforcement and law enforcement cross reporting. This is obviously it's fairly straightforward bill. I think that Director Schmidt we've kind of talked about the issue overall. What I would say is that there was a discussion in our group about if this was in the right place, and that we're only seeing, of course, that subsection D of the statute. Subsection C of the statute, just for the edification of the committee, is DFS notifying law enforcement and requesting and may request assistance from other agencies as well. So C is going one way. D is where there is a difference and there's a determination and there is no reporting requirement per se to DFS. So that's the gap or the reciprocal approach. I will note that there is not, I know the discussion came up with Chairman Larson about a timeline. I will note that there is not a timeline in C for DFS to notify law enforcement. So maybe a comment from Director Schmidt about if we were going to consider a timeline for law enforcement reporting to DFS, should we have a reciprocal one for DFS to law enforcement? Director.
Eric, Senator Barlow, if I may, before.
Please, go ahead.
So because you can't see us, we were doing some covert conversation in one of the other topics and agree with your comments that in C that time requirement is not present. And I think the intent would be that we just conform D with the current language of C. And we will make that motion and with a couple of other tweaks there, but on that time requirement, just making conforming. It seems to work well currently with DFS reporting to law enforcement without a timeline requirement. And so we would anticipate that likewise, it would work well the other way.
Thank you. And I'll look forward to that, to your amendment. I'll just note that based on that conversation, understand that C says a vulnerable adult is suspected of being abused, neglected, etc. And D determines that a vulnerable adult. So there is actually a significant difference. Again, C is the allegation or potential that something, and D, I would argue, is there has been a determination. So hopefully that's part of the discussion. So any further general discussion?
Mr.
Bill.
Eric, the proposed bill strikes through determines.
Oh, no, I recognize that. I'm looking at current statute. So, yeah, thank you.
Right.
All right, any just further general conversation and then we'll just put, or otherwise we'll just work the bill. So let's just work the bill, page 1. And because I'm not in the room, I know there's the rest of the bill is on page 2. So if there's a substantive motion on this bill, I guess probably either Chairman Larson or Director Schmidt, if you'd like to present that.
So, Mr. Chairman, if I may, I would looking at C and trying to use to conform D with it. What I would suggest is on line 2, we strike the second word, which is A. Strike through officer. Really continue with the proposed striking of determining. And then I'll read this when I'm done. On line 3, I don't change anything in the bill. On line 4, I don't change anything. On line 5, I leave the stricken language and strike the new language, which is the officer, and replace it with law enforcement. And on line 6, no change. Line 7, no change. And then I can't quite see through my scribbles. I may need to go back to line 2 and make sure that officer is stricken as well. And so the way this would read, the structure would be just pretty much similar to what D says, and it would say, if law enforcement receives a report that a vulnerable adult is abused, neglected, exploited, intimidated, or abandoned, or is committing self-neglect, law enforcement shall notify the department concerning the potential need of the vulnerable adult for protective services. And so with that, now I would look to the director and see if she concurs with that intended language.
Thank you. Director Schmidt, you've heard the language. And first of all, does anybody need a clarification on how it reads now? I don't hear anybody. So Director Schmidt.
Thank you, Mr. Chairman. Mr. Chairman, yes, we agreed just for the consistency purposes, but then as you said it out loud, looking even further at conforming language. Under C, back to Senator Barlow's point, after receipt, this pertains specifically to the agency. When the agency has received a report that a vulnerable adult is suspected of being or has been, and the proposed language in D does not include that is suspected of being or has been language. And honestly, I didn't even recognize that till just now.
So, Mr.
Please.
Chair, or Mr. Chairman, if I understand that correctly, then perhaps what we would do is on line 3 of the bill after report, say a report that a vulnerable adult is suspected of being or has been, or let's see, a report that a vulnerable adult is suspected, so it'd be after vulnerable adult is suspected of being or has been, we would insert that language. Is that correct?
Yes, Mr. Chairman.
So I would add that to the amendment.
Yep, I understand. Trying to be consistent. Thank you for that. Does anybody have any questions? And go ahead, Speaker Summers.
Yeah, Mr. Chairman, just, when we get done, I think just give LSO the flexibility to ensure that that's consistent between the two sections, that we didn't miss something in our amendments, and I think then we'll be fine.
And I appreciate that. I certainly will give some latitude to ensure we're getting the intent of the language. Any further discussion on this amendment? Chairman Larson.
That's my motion.
Any discussion on the amendment? Anybody on the amendment?
Second.
All right. Is there any objection to the amendment? Because I'm in a room by myself, and doing a voice vote makes no sense to me from this end. Is there any objection? Let's talk about objections. If there's no objection, then we're just going to advance it as an amendment to the bill And the consideration here is this bill, when we get, so without objection, this amendment is adopted. Gives with a little bit of latitude for LSO to ensure we're consistent between subsection C and subsection D. All right, with that, it is adopted. Is there any other amendments to this bill draft? Amendments to the bill draft. The one thing I do find interesting is the effective date. And, you know, if we believe that we want to get consistent sooner, effective immediately may be of interest, but I certainly, it's fine either way, but it's just something to be considerate of. All right, no further amendments. So, Mr. Chairman, I'm going to leave this in your case. If you think with the amendments we've had and the discussion we've had, this is adequate to move beyond this committee, we'll do a roll call vote on this bill as amended and drafted. We'll just let the chairman just ensure that it's consistent with our motions. And then that way you can advance it to a standing committee quicker. Is that an acceptable way to proceed with this, Chairman Larson?
That's accurate. That is our desire.
Okay. So with that, Katie, if you will call a roll call on the bill as amended with the latitude for the chairman to verify its consistency with the discussion we've had, and then so they can advance it as they seem fit to a standing committee. Please call the roll.
Roll call for 24 LSO 0023 DFS and law enforcement cross-reporting as amended for a task force recommendation. Senator Barlow.
Aye.
Senator Nethercott,
Aye.
Representative Summers. Representative Zwanitzer. Co-chairman Larson. Co-chairman Baldwin. Department of Health Director Johansson.
Aye.
Director of Department of Family Services, Director Schmidt. Aye. Director Shannon of Department of Corrections. Laurel Ballard for the Department of Education. 10 ayes.
Thank you very much. So Chairman Larson, Chairman Baldwin, it'll be up to your discretion, obviously, to review the bill, ensure it, or the draft, ensure it is consistent with our understanding of our work, and then to sign it as you see fit. The next bill for our consideration, Mr. Chairman, is LSO 0021, which is Emergency Protective Services Effective Period. And potentially, maybe just obviously it's pretty simple. We're going from 72 hours to 14 days, 3 days to 14 days. Director Schmidt, would you like to, since it's your agency that's responsible for these emergency services as a rule, anything you would, or always, I guess, may order the department. Anything you'd like to say about this bill draft? Did I lose the world?
I can hear you.
We seem to have lost the room. Chairman Larson, can you hear Senator Nethercott or myself?
He's frozen.
Well, all those in favor of the bill draft as presented, it's unanimous. It's maybe not, maybe it's a tie vote, you and I. Chairman Larson, can you hear us?
We might have to come back on.
So let me shoot a quick email to Katie.
we're gonna kind of carry on here. Is there? Anna, were you part of the conversation when they had this? And get close to your mic, thank you.
Mr. Chairman,
So, was there any concern from the court perspective that was too much time?
Mr. Chairman, not that I recall.
Okay, is that consistent with your understanding, Chairman or Director Schmidt?
Mr. Chairman, the one thing that our attorneys general pointed out is that the current draft as written still includes excluding weekends and holidays. If you look at the current statute, is 72 hours excluding weekends and holidays. If we leave excluding weekends and holidays in, that gives us even more time. We are fine with just the 14 days and striking the excluding weekends and holidays, if that makes sense.
We'll address that. Yeah. Eric, can you hear us?
I can hear you now. Yeah, I left the room and came back in.
Okay. So in your absence, what we've done is we heard conversation that the AGs in their conversation back with Director Schmidt pointed out that in the existing statute, it also allows for additional time for weekends and holidays. Director Schmidt said that we could line through that in 14 days would be adequate, including holidays and weekends. And so that may be a possible amendment, come and shorten that time up just a little bit.
Sounds good.
So with that said, is there any other comment or public comment on this bill draft? So working the bill, there's very little that we change in the bill, and it's all on page 2. Are there any amendments? Sure. Go ahead, Representative Summers.
Mr. Chairman, thank you. On page 2, line 11. After 14 days, strike excluding weekends and holidays, and then insert the period. So period goes after 14 days.
And the comma.
And the comma.
Anna, does that make sense? Okay, that's the motion. Do we have a second? Second by Chairman Baldwin. Those in favor of the amendments, aye. Those opposed, if any. Okay, any other changes or proposed amendments to the bill? Okay, we're going to go ahead and vote on to move 24 LSO 0021 forward. Katie, would you take the roll?
Call for 24 LSO 0021, Emergency Protective Services effective period. Senator Barlow,
Excused.
Senator Nethercott,
Aye.
Speaker Summers.
Aye.
Representative Zwonitzer. Co-Chairman Larson,
Aye.
Co-Chairman Baldwin.
Aye.
Director Johansson for Department of Health. Director Schmidt for Department of Family Services.
Aye.
Director Shannon for the Department of Corrections. Laurel Ballard for the Department of Education. 5, 9, I, 1 excused.
Thank you. So I think, and Chairman Nethercott, you've been part of these conversations on the bill drafts. Are you comfortable with walking us through the work you've done on the vulnerable population definitions?
I certainly can. And Senator Barlow is also trying to come back in. Katie or whomever, it says he's been removed. So I'm not sure if we can.
That's our vindictive nature.
Improve the meeting. So
Yeah. Well, give us just a second. We'll see if we can get him on, but if not, if you would kind of be glancing at that and preparing just a little bit.
I sure can. And Mr. Chairman, I'll just go ahead and proceed. He's certainly aware of the bill draft. I almost called you Your Honor. I'm flipping back and forth from the day job to this job. So as you can see, committee members were on 24 LSO 15 working draft 0.5. This is that definition for vulnerable adult. You can see the memo that was previously provided to the subgroup concerning different definitions for vulnerable adult across the country. And here is our vulnerable adult definition here. And so we're just work the bill draft. I'll just walk you through it. Vulnerable adult means any person 18 years of age or older who lacks the capacity to consent or who is unable to provide for their own care or protect themselves from abuse, neglect, exploitation, intimidation, abandonment, or self-neglect due to any of the following. And it's now physical, emotional, developmental, or mental disability, or a dysfunction that may or may not be due to the infirmities of aging, cognitive impairment, or limitations in hearing, vision, mobility, or the inability to carry out the activities of daily living. Illness, accident, or injury, as you can see. And then on page 2 or page 3, residency in a nursing care facility or assisted living facility or other similar care facility or institution. So that's the proposed changes. As you previously heard, there's not support to change the definition from how it currently reads, which of course you all understand is not the addition of the red language. And I think it just has really to do with the court and others' current familiarity with the statute and concerns about unforeseen consequences or unintended consequences with any change. There is case law interpreting this definition currently without our changing. And so everyone, I think, is fairly satisfied with the definition. Despite those challenges, we hear from prosecutors that they don't think the statute is definite enough. But that's where it stands. I'm happy to stand for any questions, Mr. Chairman.
So I do kind of have a question. I find myself a little bit confused. I think the intent when you guys started was how do we provide clarity so that our prosecutors feel comfortable with the definition. And it really wasn't, this really kind of come out of that 2017 task force recommendation. And so then you guys have done this work. We looked at a lot of different definitions. Then we heard that, as you pointed out, that there was no, we like it like it is, just we think we're okay. And then today I've been somewhat surprised to hear that changing somewhat, that I'm hearing from AARP and as he's talked. So I guess my question is we cannot move the bill and it just goes away. And is there any harm in that? We could let the bill live to see a standing committee and give associations and those involved that have now been chewing on the bone for a while, maybe come back and yet say this is a good thing, or no, we slip on it, kill it, don't let it move forward. Any recommendations that you would have for us there, or guidance?
Mr. Chairman, I would recommend that we keep it on our next meeting as an agenda item, primarily just to continue to get further maybe public participation or from those county attorneys. I know we heard that a number of them were contacted and had some feedback and maybe wanted to participate but couldn't because of the timing. I know in speaking to my local district attorney, they didn't really, they were contacted by LSO to give kind of their feedback regarding whether or not the definition should be changed. but they're they're generally unaware of this greater effort going on in the legislature on this topic. And so I do think maybe another ping to all of them saying, take a look at this proposal. Now, what criticisms do you have is worthy of conversation. And I may not have that. I wasn't obviously part of the conversation between LSO and the county attorneys, but that's my understanding back from them.
Representative Summers.
Mr. Chairman, as I looked at this revised language, it seemed to make it even more nebulous than before. That doesn't mean we can't find language that tightens up whatever the holes were. But I guess I was not real comfortable with this expanded language because I don't know, I just thought I didn't think it improved anything. And so I'm actually really glad that they came back with the recommendation they did, but I think it's a good idea maybe to keep it on our next agenda and, maybe we can get some prosecutors in the room and others to talk about, the definition and why the definition works, doesn't work. I think we need that voice in the room.
Thank you. And, this is interesting because I thought it really added clarity. And because it talked about down there in the large capital A, it talked about and lined out the causes for them not being able to care for their own. So with that, I think let's walk through the bill and see if there's any amended language, that we need to make to this point. But I think we'll move this along with that first bill just to our next meeting and consider it for that time as well. So we're not going to throw it out with the bathwater yet. So
Mr. Chairman, if I might.
Hold just a second, Tara. Go ahead, Katie. So you want me to tell him that? Take that microphone. And
Senator Barlow, if you can hear us. I see that you joined by phone. If you would like to speak, it's *9 to raise or lower your hand and *6 to mute and unmute yourself.
Thank you.
Senator Barlow, if you'd. Yep. So Senator Barlow, we've kind of walked through the bill, why we left you out there in no man's land. Chairman Nethercott walked us through the bill, had a conversation on the conversations you guys have had. There seems to be an appetite that maybe we move this bill to the next meeting and come back and reconsider it, giving the prosecuting attorneys a little more time to study and have a conversation with us on our intent, and then maybe come back and have that consideration. Does that meet your blessing? Okay. Senator Nethercott, would you please continue on with your thoughts?
Mr. Chairman, if I may, just to help the committee maybe understand some of my motivation for inviting the county attorneys back with further comment, which we've already decided, but I think in all 50 states, all the prosecutors claim that the statute they're not comfortable with it. And having looked at the definitions in all 50 states, essentially, they're all kind of uniquely have their own ambiguities to them. And I really wanted to just inform them of that our statute is not unique, whether we amend it or not, in some of its ambiguity, to kind of give them that confidence or that understanding. And then really invite them to say, well, listen, you have the ability to change it. What would you do? And walk them through that exercise. And that might eliminate some of that hesitancy, whether we change anything or not. I just think their continued participation is important if we want to see increased confidence in prosecutions on this topic.
Thank you, Senator Nethercott. So is there anyone that is not comfortable with moving this forward to the next meeting? Okay. So as I see that, we had those bills and what we've elected to do. Anna, please direct me on the civil course of action. We are going to make some changes, bring that bill back, correct? On the draft 23 on law enforcement reporting, we've passed that bill. Chairman are going to decide where that goes.
That's correct.
And on emergency protective services, extending that time frame, which is draft 21, same, it's been voted on, and we'll move that forward.
That's right.
And then the last one on the vulnerable adult definitions, we're going to take another look at that at our next meeting.
Yes.
Okay. Is there anything else on this portion of our meeting that on drafts that we've missed? Anna, have we got them all?
You've gotten them all.
Okay, with that in mind, thank you. We took all the public comments, so I think we're going to go ahead. Let me look at the time here. We're going to go ahead and take a 15-minute break and come back, and then maybe we can get hold of, I think we've got, I never know what to call Jeremy, if he's a director, a superintendent, or all around good guy for the Life Resource Center. He'll be up next. Okay. Are we there? Thank you. Committee task force members. We got an opportunity to finish the day up with a conversation with Jeremy Forbes, who's the administrator here at the Wyoming Life Resource Center, and Director Joe Hansen, kind of on current events, on staffing, programs, things we're looking forward to on the Life Resource Center. And then Jeremy is offered to take us on a tour and see what buildings we'd like to see. Tomorrow, we're going to be having a conversation on adolescents with high behavioral needs. And in the meeting materials this time and in the conversation we had last time, we talked about how we provide those services to that population, 15 to 20 kids, and where. And there was a couple of conversations on either the state could contract that out. We heard from some of the associations that there's interest and ask us to draft an RFI. And we've done that and we'll be talking more about that tomorrow. So if the response back from that that process is positive, that process would continue forward. If for some reason there's no interest, or the how all of that develops proves unfruitful, Plan B has always been that we would need to consider an option at a state facility where we have physical assets, or where we could develop physical assets. And so part of the tour today, and I hope it'll be the first part of the tour for these folks, is that some of as we've moved the population into the new Wyoming Life Resource Center residence, we have vacated some of the cottages that was previously used, which Mr. Forbes will tell us is about their harden and ligature components built into the structure, how or how not that may be applicable to this population and how that could serve. So I just bring that up as we go on the tour, that we'll go look at some of that first and then go look at the others. And then we'll conclude our meeting from that tour. So when we get done with this brief presentation, that will end our YouTube for the day. And we'll take the tour, and then we'll be back here again tomorrow at 8:30 in the morning to finish out the second day. So Mr. Forbes, the floor is yours.
All right, thank you, Mr. Chairman, members of the committee. My name is Jeremy Forbes. I'm the administrator of the Wyoming Life Resource Center. I've had the privilege of being in this position for the last 6 years. And I was asked to come and give some updates on the Life Resource Center, and then offer a tour, both of our existing new facilities, as well as some of the potentials for an adolescent placement, should the legislature deem that necessary. So the Life Resource Center obviously has been kind of a mainstay in Wyoming for over 100 years, and due to the graciousness of the legislature and two governors, we have a new campus that we just had our ribbon cutting ceremony last October, and I saw several of you there. So thank you for your continued support for our programs. We currently serve Wyoming's most vulnerable citizens in two different licensing capacities, one being an intermediate care facility license, which we've had since 1995. And the other one is a skilled nursing facility license, which we just acquired in 2022. And as part of that, we admit individuals here who are maybe not best served at that moment in their life course in the community. And it's our job through therapeutic and medical interventions to get those individuals ready to transition back to the community. So we have 100 licensed beds between our ICF and our skilled nursing facilities. And at this point, with the exception of having a robust staffing model behind us, we are admitting folks who need that level of care and getting them back out into the community. So.
Mr. Chairman, if I may, Stefan Johansson, Director of the Department of Health. Just want to say at the outset, it's been nice to have our first official legislative meeting at the new Wyoming Life Resource Center, and you are in the Larson Professional Development Center. And just like its namesake, I have to mention, might not look like much, but its utility is unmatched. So we're just pleased to be able to host in this facility after so many years of rethinking, rebuilding, and building. It was a wonderful thing to cut the ribbon and know that we're on track for this facility to be sustainable and really unique to Wyoming over the next multiple generations to come. It's also a facility, as director of the department, I'm proud of all of my facilities. I'm incredibly proud of this facility. And that starts with Dr. Forbes here and his whole leadership team and all of the staff that work with the populations, and especially the new populations that we're serving. It's not an easy job here, but it's a necessary job. And this facility, like our state hospital, is a true safety net for the state. In addition to that, I think the mission of one facility with long streets between here and the state hospital, we've taken that and we've broadened that to our other facilities too. So those of you who were connected to or participated in the facilities task forces over the years should know that at our retirement center in Basin and at our Pioneer home in Thermopolis, we are treating and providing services for current and former state hospital clientele. And it's been a challenge, but I think it's been a healthy rethinking of our mission and rethinking of our department as a safety net with our facility space for the state. As Dr. Forbes mentioned and Chairman Larson mentioned, at all of our facilities, and this is not unique to Department of Health, this is health and human service industry, we are really struggling on the staffing side. There's no other way to say it. We reached some pretty historic staffing vacancy levels at all of our facilities, but with the state hospital, the Life Resource Center, and the retirement center in Basin being our premier examples of the challenges that we faced. And for the most part, we've kept our census flat at those facilities, which is, again, I have to commend the leadership and the staff at all of those locations for doing that. We see light at the end of the tunnel with some additional interests and applications that we're seeing following the implementation of the new compensation package from the legislature. And we hope that continues to grow because what these facilities mean is not just the residents that we serve here, the staff that we have here. There's upstream and downstream impacts for your communities, whether it's in the Title 25 system, the Title 7 system, your DFS system. There is a large range of impacts if these facilities that we've rethought as a state don't achieve their full missions. And if we can get fully staffed and really turning and burning with our operations here, those benefits will compound over the months and the years to come. So we're working really hard to get our facilities staffed up. And that brings us to the topic that we'll discuss tomorrow as a task force, but that you'll kind of be seeing or at least putting eyes on as we take the tour today of a new policy decision that we're wrestling with as a state, which is with these 10 to 20 very high needs adolescents that we deal with between the three agencies, Department of Health, Family Services, and Education. At any given time, we don't have suitable places other than detention centers, jails, and emergency rooms to provide better care and housing for those adolescents. And as you know, we've taking a diverse investment approach. We have drafted a request for information or an RFI that I know the task force will look at, that we could potentially as a state look at contracting that out. There's physical plant space outside of the state-owned assets that could potentially be used, and we'll discuss that. But another option is using a state-owned asset or a physical plant at one of our facilities. This one here at the Life Resource Center potentially being one of them. I mentioned our staffing issues because I want to be very clear with the committee that while we have dabbled in this mission over the past 1 to 2 years, with Jeremy and his staff being voluntold to help out a few clients that meet that adolescent definition of really extreme high behavioral needs, it's a difficult thing to scale, especially right now in light of our staffing issues. But the reason we're here and sitting in front of you is because we're absolutely open to that discussion, given what we've had to do over the years in emergency situations, and given the policy decision that sits in front of us as a task force in the legislature writ large of what is the state's role in high needs adolescents that we are struggling to find a placement for, optimistic that we will find a more suitable placement for. But in that interim period, what's the best option for those kids? And what we want you to see today is not only our new campus, but some of those assets we have on this campus that could potentially be repurposed in light of that policy problem and service delivery problem that the state is facing. So again, I'll close and just thank you all again for being here. And like I said, we've had some challenging times over the past 3 years at our facilities, but couldn't be prouder of these folks and what they do day in and day out to really serve the most vulnerable of the most vulnerable in our state. And Mr. Chairman, with that, Jeremy and I will stand for any questions you all have.
Then Representative Summers, please.
Mr. Chairman, thank you. And some of it, as I just missed the population, but one of the old populations you had was acquired brain injury. And how many of those folks do you still have? And then remind me of the population that is your mission now. And then kind of on a different, on this high behavioral needs student, is this something above and beyond? So just for my edification, something above and beyond what's the CBAR-V in Jackson. So I assume it is, right? And, and then this is a statement just a statement by me, is I don't want to see these kids shipped out of state. It's a wrong policy for the state of Wyoming.
Director or Jeremy, please.
Okay, thank you. Mr. Chairman, Representative Summers, excellent questions. I will start with our mission and who we currently serve. And I'll jump into the folks with traumatic brain injuries. So under our 2 licenses on the intermediate care facility side, we take care of folks who have intellectual disabilities, which would include a traumatic brain injury before the age of 21. These individuals also have to manifest what we kind of deem to have exceptionally difficult behaviors. So under that license, that's exclusive to the population we admit. On the skilled nursing side, we admit under 3 different criteria. One is people with neurocognitive disorders, which would include people with traumatic brain injuries, assuming they got those at the age of 21 or older, as well as other neurocognitive disorders such as dementia. And for those individuals, again, they would have to manifest the exceptionally difficult behavior piece, because the private community can certainly help those individuals who don't have that. Additionally, we take folks who qualify for skilled nursing level care, who qualify for the extraordinary care reimbursement from CMS, which means people with vents, trachs, morbid obesity, or co-occurring psychiatric diagnosis. So some of our people who are currently at the Wyoming State Hospital would qualify under that side. And then we have kind of operationalized a catch-all for, again, vulnerable citizens, and that's people who are hard to place. So for whatever reason, they're unsuccessful in their current living arrangement. They still need that skilled nursing level of care. And maybe they've had multiple denials in the community and they just need someplace to go. So those individuals would fall under that category. In terms of numbers, I think right now, between our 2 licenses we have approximately 10 individuals who have neurocognitive disorders with that traumatic brain injury side.
So if I may follow up on that conversation a little bit to go back into some historic perspective and ask for Director Johansson's confirmation or Director Schmidt's confirmation on this, because she was in the Department of Health at that time. Prior to our redesign of what these facilities would do, the acquired brain injury population came here under a program called Visions. And the intent of that was, is we knew that if somebody was the victim of an acquired brain injury, that the sooner they got the help, the sooner they could recover much better. And the intent was to have, and I can't remember the population, seems to me like it was around 20 or so, that was bed space we had in there. The intent of the design of that was to bring those in and get them stabilized, dismiss them back into the community, their home, whatever. Our statutes at the time were then challenged by people who seen the benefit of the care that was given to these people with acquired brain injuries, and they didn't want them to leave here. And so then it was challenged, and the state just says, okay, this population would stay. And so that population took up those beds, and people who received subsequent brain injuries had no place to go. And so it was a clog in the system. And so that was part of our redesign, is this legacy population that was here, we're going to keep them, boom, just like we'd promised. But the intent was, is this is a safety net to help get people stabilized and then go back into the community, including those with acquired brain injuries. Am I summarizing that accurately, Mr. Forbes?
Mr. Chairman, you are, and I would just like to add that with the exception of one individual who was on our previous Visions program, every other resident whose guardian has chosen for them to remain with us has naturally moved over into our skilled nursing facility, still within that basic program though.
Perfect. And then I think I would also, just as we start this conversation tomorrow, again, to the good speaker's comments on when I think of shipping kids, I think of shipping cattle, and we're not shipping cattle. But I think we also need to be cognizant of what's in the best interest of the child, depending on his behavioral needs. Similarly, it just isn't right that our engineering students at the University of Wyoming can't get a nuclear engineering degree. They have to go out of state and get it to satisfy those requirements. And I know it's kind of a wonky comparison, but you'll have some kids with behavioral needs that we don't have those services for here or in the state, and to stabilize them and give them the best benefit in life and the most promise of being able to return back into the community sometimes require that they go out of state. Director Johansson.
Mr. Chairman and Speaker Summers, to your point, I would totally agree with the sentiment. And it's something we share too, that for whether it's children that are in our under our care or on our Medicaid program or on our waivers, we absolutely want to keep them in Wyoming and provide those services and support their families and their homes as much as we can. But to Chairman Larson's point, there are very specialized, especially when you start looking at your more severe part of the continuum of the autism spectrum disorders. There are specialized services that Chairman Larson's correct, we just don't have in the state. And so what we look to do is to, if there's an adequate placement with those specialized services that we can finance within our boundaries and in our rules, we will leverage that if possible, with the express intention of bringing them back home. And I will say, to the credit of a lot of folks in this room, and Director Schmidt was in the Department of Health when we really started this effort as well. But on the Medicaid side, a lot of those out-of-state placements that were the majority of our placements in psychiatric residential treatment facilities, or that similar level of care in previous years, were heavily out of state. That has changed over the last 6 or 7 years. And so there's good progress there, but I think there's a balance and a recognition of what we have in the state of Wyoming, what's possible to scale, and what might be available in our peripheral states, that we sometimes have to leverage as well. But the intent, and we build our policy around it too, whether it's on the payment side or on the regulatory side, that there's regular and frequent check-ins and authorizations to continue the service, because we don't want folks sent to Arkansas and kids languishing in a facility that the state doesn't have an interest in anymore, because, out of sight, out of mind. That's absolutely something that we're cognizant of, and want folks back here as quick as possible. The last shameless plug that I'll make is connected to all of this is our ongoing efforts in the behavioral health redesign. And we don't often connect this population with that, but it is a huge component of what I think we need to build, in addition to facility-based care, that our community providers are geared as much as possible and incentivized as much as possible to treat this population. And the high needs children and their families, as we discussed earlier, are a statutorily authorized priority population in the redesign. And even before that takes effect next July, we've had a handful of what I would call success stories, kind of early adoption of that behavioral health redesign concept, where a child needed to go out of state and found a facility, but the facility went under, discharged all of its children, and through the effort and dedication of community provider, that child is stable at home in Wyoming with wraparound supports in the community. So from my perspective, this absolutely can be done. It's not perfect in every scenario, and we do have to leverage out-of-state resources. But I do think the concepts this legislature has advanced over the past 4 or 5 years with our facilities, and now with our community reforms, are absolutely a step in the right direction, because we've seen some early successes with it.
One final comment, because I think it fits really in, Mr. Speaker, to your comments and in the whole approach to this mental health issue, this vulnerable adult issue, and all of these things that this task force is trying to do. And I just want to, this is the time of year I start thinking about what I'll be doing in December, and that's budget items. And I start working with the agencies pretty soon to start getting my head around this. It's really important for this group, and to help others know that we've been having this conversation. You'll remember in 2021, we had the step 2, step 3 cuts. And Department of Health took $112 million or thereabout in cuts, and mental health had some step 2 and step 3 cuts that then we replaced with one-time funding. So those cuts didn't go away. We funded them one time, but we didn't put them back in their standard budget. And we've dealt with that since that time. Now, those, we were able to cover those because of the enhanced Medicaid reimbursement rate that freed up some other general funds that we were then able to shift and pay for that. So you'll recall those conversations, how we did that. Well, that's gone. Okay. That's gone. And Mr. Speaker, thank you for being here, because we're going to have in our 2 chairmen of labor and health, is with all these advancements we've done and this stabilization we're going to do, those cuts, even though they've been funded, will need to be added back into that standard budget. I don't have the numbers for you, but just know that know that it's coming, and it won't be a few pennies. It's pretty significant, I would guess. And so just kind of preparing us for that conversation based on what we're doing here today. So with that in mind, we are excited to follow your lead. Thank you. Katie, we can go ahead and close this meeting and remind the public that we'll be here again tomorrow at 8:30. Thank you.